Good morning. My name is Ken White, and this is the second of these I'll be doing for Door of Hope. And I'm here today to give you the training on sexual harassment prevention that's now mandatory in California for any organization or business with a certain number of employees. I've done this a lot of places, a lot of different types of places, from religious organizations to activist organizations to police departments and municipalities to law firms, and they're all a very different experience, I can tell you. And some of them are more comfortable to be talking about these things than others for different reasons. But the bottom line is that it's all very understandable and it's something we can get through and people do get through all the time. Although I know it's not what everyone looks forward to, having a lawyer talk to you about sexual harassment for a couple of hours. So let me talk to you about what we're going to do today, what we're going to talk about. We talk about why is it important to prevent sexual harassment, what is sexual harassment legally, and what conduct is prohibited by the law. We talk about how to avoid it, to prevent it individually and on an institutional scale, how to report it if you experience it or observe it, and how you behave during an investigation by your employer into an incident. Now, I'm going to make a few promises at the start of this because, again, it is for many people a somewhat uncomfortable subject. I'm going to promise that I'm going to answer your questions today if they have anything to do with sexual harassment prevention, and answer them privately soon if they're on another topic. I do tend to draw a lot of off-topic questions about federal criminal law and traffic tickets once, and just stuff. Always happy to answer, maybe not right in the middle of it if it's not on topic. There are no dumb questions, and there are no illegitimate concerns. This is a fraught area. Sometimes people are concerned about asking a question that it will sound dumb or impertinent or something, but people have questions, and if you have a question, it's likely someone else in the room has a question. And I get a lot of good questions. I've never been offended by one. I've never had the group laugh at somebody for one unless they meant it to be funny or agreed that it was funny. And sometimes they're very illuminating. I've only been completely surprised by a question once, and that was at a legal organization where the director asked me what I thought about doing a team building exercise at a nudist camp. And I just sort of blue screen of death for about 20 seconds. I just could not process that completely, but I recovered. The answer was no, by the way, in case you didn't know. This is not rocket science, okay? First of all, it's applied by lawyers who are not rocket scientists, and the culture tries to portray it as being complex and scary, and in fact it is not. A lot of it is stuff that you will be able to intuit from very few simple concepts about acting decently towards your fellow human beings. And finally, I promise, you can ask me questions here, or you can ask them privately, in person or through emails to me, and I'm always happy to answer questions. That's part of what I do in giving this training to any organization or group. And I'm going to be direct as I can be, like a human being, like a lawyer, and try to give you actual answers to questions, okay? Now, when I come in to do this, a lot of people haven't taken harassment prevention training before, notwithstanding this now required for employment situations in California, and a lot of people's expectations about it are driven by what the media says, by the way it's portrayed in a sitcom, or by the way someone angry on the radio shouts about it, or about something like that. And so people come in with a lot of anxieties or misconceptions about sexual harassment prevention training. One is that everything I say or do can be harassing, and I'm terrified. This just isn't true, okay? Harassment is well defined. There are all sorts of ambiguities in law, of course. Lawyers can make an argument out of anything, but this is an area where it's knowable. I can explain to you what's likely to be harassment or not. Anyone can sue anyone for anything. That's another common anxiety. Why do we even bother trying to figure this out when no matter what the rules are, people can sue? Well, the answer is yes. Anyone can sue for anyone, but not everyone can succeed. Most lawsuits that are frivolous are dismissed early, and the standard for proving sexual harassment in court is pretty high. And some people would say that's a bad thing, some people would say it's a good thing, but the way in which unquestionably a good thing is that you can train people to avoid sexual harassment. You can train organizations to deal with it, investigate it, prevent it in a responsible way. Another common anxiety or complaint. This is all a political thing. It's all driven by political correctness or fill in the blank, whatever interest group you want. I don't really take a stance on that, but the bottom line is the law is the law. The requirements of California law are what they are. Your moral obligations to treat these people decently are what they are. And whether or not you think sexual harassment law is where it is for politically illegitimate reasons, you've got to deal with it. It's the real world. Finally, a lot of people worry, particularly in corporate settings, if I report harassment, I will be punished. There will be retaliation. But there is, in fact, very strong law protecting you from any sort of retaliation if you ever report harassment. In fact, retaliating against somebody for reporting or complaining about harassment is one of those red line, when you cross this, you have put the employer in a catastrophically bad situation type of things, where even if there's no problem before, the cover-up is worse than the no problem. So you are protected from retaliation. Okay, well, let's talk about, because people come into here saying, what are you going to tell me to do? I mean, who are you to tell me how I can talk to my coworkers? Who are you to tell me how to think about these issues? But that's not why I'm here. I can't tell you what to think, what to feel, what to say to your family at home. Whether you tell jokes at home that would be inappropriate in the workplace is not of interest to me. What to say to your friends outside of work, or anything like that. I don't want to get into your head. What the law does do, and can tell you though, is how to act at work within a reasonable frame of reference of treating people decently. How to act when you're representing Door of Hope. How to act when you treat your coworkers at work or at work-related events. And how to treat people you supervise. The law absolutely can control how you do those things in your official capacity as an employee of this organization. So, part two of this is, why do you need training? Why is this necessary? Well, the first and most obvious reason is because the law requires it. California law for a few years has required businesses or organizations with more than 5 employees to give training on prevention of sexual harassment and what it is. And those training requirements have steadily grown. It used to be for much larger companies, it used to be only supervisors, and it used to be a narrower range of issues, and it has gradually expanded to include much smaller organizations, supervisors and line employees, and a much wider range of issues. So what I usually tell businesses is, don't get too into thinking, wait, is it our turn? We have to do all employees yet? Are we quite big enough? The safe thing is always to comply with the maximum thing the law would require, and you won't get in trouble on that. In addition, there's an affirmative duty, a legal duty for employers to prevent harassment, to take reasonable steps, and giving training is part of that. So doing a training like this is part of how Door of Hope lives up to its legal obligations to take reasonable steps to prevent harassment. And why else do you need training? It actually changes problem conduct. You know, a lot of people come into this pessimistically, that you can't change human behavior. Maybe less so with religiously based organizations and with corporate organizations. But it's not true. I find that by dispelling people's misconceptions and addressing their anxieties about what the law is, and explaining it to them so they can intuit what the answers are and see why those are the answers, you really can change people. A lot of the time, it's more a matter of getting them past that point of anxiety, that this is unknowable, that this is all vague and ambiguous, there's no way I can figure it out, to a point where they understand, I can figure this out, I know this. This is something I call the 85-10-5 rule. That adds up to 100, you might notice. 85% of the people I talk to would never do any of the things that I'm going to tell you not to do, okay? They're not, on the worst day, going to stray into areas that I'm going to tell you are dangerous. 10% of people in almost any organization might do those things, but will listen to me and can be taught not to do those things, persuaded. It can be pointed out to them how the conduct is a problem. 5% of y'all are unteachable. A lot of those are lawyers. A lot of those are executives. A lot of those are powerful people. A lot of the 5% simply are going to do what they want to do. But training gives an organization legal protection. So even when that 5% acts out, and they will, you can say, look, we did our best. Judge, just a 5%, what are you going to do? We tried. So that's part of the purpose. That's a little cynical about human nature, I guess, but I have not yet been persuaded that it's wrong. Training corrects misunderstandings. The culture is generally terrible in terms of explaining to people what this area of the law is actually about. You'll have all sorts of misconceptions about what it really is. It's relatively straightforward. You'll come out of this, I think, saying, okay, that's actually pretty simple, I get that, and it's not the way the people who are upset about it or shouting about it say it is. And so correcting those misconceptions is valuable. And finally, it teaches supervisors how to deal with problems. A lot of problem situations with sexual harassment come not because the initial thing that happened is so bad, that the inappropriate comment, that the asking someone for a date, that the dirty joke in the workplace. It's not that thing was so terrible, it's that the reaction to it, everyone just falls apart and does the worst thing possible. That's why when I'm working with clients and they call me to say, what should we do? We just got this complaint. The usual first thing I say is stop doing anything. Just, put down the computer, step away from the computer, let's talk before you do anything. Okay? This training will help organizations react, not in panic and not doing bad things in response to complaints, but in a way that's productive. So again, often it's not the wrongdoing, it's the cover-up or reaction to the wrongdoing that gets people in trouble. And finally, the training protects door of hope litigation. So when you, if you ever have a problem and if the organization is sued, the fact that you tried your best, that you gave training, that you took it seriously is going to help. So that's why you need this. Why is it important to prevent sexual harassment? This seems like an obvious question, but it's not always obvious to people. Well, it's illegal. It's against door of hope policies. It can lead to personal liability, and by that I mean to you individually as a supervisor or even an employee if you're involved with it. It can lead to liability for door of hope, which can be very damaging to an organization, both its reputation and its bottom line. Litigation is expensive and extremely unpleasant. I've never had a client who enjoys litigation. I've had clients who really look forward to suing someone. I've had clients who really look forward to defending a bogus lawsuit. I have never encountered a normal human who enjoys being in litigation. Sexual harassment allegations and cases will hurt your career and reputation. It hurts morale and productivity in any organization, and it's wrong. It's morally wrong. Treating someone other than as a fellow human being entitled to respect is wrong. And this is something we should understand as an organization with religious roots, because it's biblical. I have a quote from Peter: "Finally, all of you be of one mind, having compassion for one another. Love as brothers, be tenderhearted and courteous, not returning evil for evil or reviling for reviling, but on the contrary, blessing, knowing that you are called to this, that you may inherit a blessing." So particularly in an organization that challenges itself to live up to biblical principles and to the teachings of Jesus, I think it's particularly important to avoid conduct that makes people feel low and bad, that makes them not feel appreciated in their workplace. So that's all why we do this training and why it's worthwhile to do it. Let's talk about the law, what it is, what you need to know. And just so you know, most of the stuff in this presentation are things that are required by law to tell you. So in doing that, we're fulfilling California law and what you have to be trained about. but we're also addressing things that I think are helpful tips that aren't necessarily in the law, but help you understand what it is and help you organize the workplace in a way that avoids problems. So it's both. Okay. The key idea about sexual harassment law, if you take nothing else away from it, is that sexual harassment law arises from anti-discrimination principles. Sexual harassment law is about discrimination against people. It's about treating someone differently in the workplace because of their gender, okay? So if you see it that way, you can wind up answering most questions about what the law is. The law treats sexual harassment as a kind of sex-based discrimination. The key concept is treating people differently based on gender or sexuality, and the concept developed in the 1980s under federal civil rights law. So you had the Civil Rights Act of 1964. Hugely important, influential civil rights law, successfully passed by Congress, and LBJ kind of riding his wave of approval and support after JFK's death and the growing civil rights movement. And the core of Title VII of the Civil Rights Act is that businesses and organizations can't treat people differently in employment based on ethnicity, gender, sex is what the law says, or religion, okay? And gradually over time, particularly in the 1980s, this started to develop. Women were treated very badly in the workplace, and I can tell you the difference between 1980 and 2020 is huge, huge in terms of that treatment. That 40 years is crucial. And a lot of companies would say, okay, well, no, we're not actually discriminating against this person because she's a woman, it's because she took maternity leave. Or we're not actually discriminating against this person as a woman, it's because we think she's not aggressive enough, or she's not deferential enough. So courts started to realize that there's a lot of stereotypes bundled into what we expect from men and women, right? And those come into the workplace. And what courts gradually said is, look, we don't care what label you slap on it. When you're treating people differently in the workplace, in hiring and firing, in promotion, in benefits, and any of these things, based on their gender, then that is discrimination. And that includes making someone's workplace miserable, barely even a workplace anymore because of their gender, sexual harassment. And so that doctrine developed in the 1980s. So whenever you say, is this or is this not harassment, ask yourself, does this involve treating someone differently because of their gender?
Question?
Yes?
Does that include preferential treatment as well?
Yes, it does.
Like if a man is given preference over a woman, that still counts as discrimination?
Absolutely. So it might not be sexual harassment,
Yeah.
but it would definitely fall into the category of sex discrimination in the workplace. And one of the issues we'll get into is, would it be sexual harassment if people in the workplace who date the boss get better treatment? The answer being yes. Okay. So, legally, sexual harassment, there are two types. One is quid pro quo, a phrase which has been in the news in a rather different context somewhat this month. Quid pro quo harassment is a demand for sexual favors, for dates, for anything in exchange for some sort of job benefits. Now, most people at this point react, well, of course that's illegal. Why would that even have to, why is that a thing? Why is that not completely obvious? Let me tell you, this was a huge thing, much more prevalent, much more of a problem, not more than 20, 30, 40 years ago, okay? You do not see as many quid pro quo cases anymore, thankfully. Society is gradually changing in that respect, but it is still illegal. The second type, the type you probably hear more about, is hostile environment harassment. That is harassment, conduct in the workplace that creates an abusive environment, that makes it someplace you're afraid to go, makes it someplace that changes the nature of your job and what you do. It's so demeaning or so unpleasant. So, the sources of this law, which again are something that you need to know about, are Title VII of the Civil Rights Act of 1964. That's what I told you about before. Federally, it's anti-discrimination law, that's it. And the California Fair Employment and Housing Act. You can always assume that California law is going to be broader and protect more people more vigorously from harassment or discrimination than federal law is. And you'll see some examples of that. So what does the law prohibit? Under federal law, it prohibits, the Civil Rights Act says it's unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individuals' race, color, religion, sex, or national origin. So, as an aside, even though this training isn't about racial or religious harassment, most of the rules you're going to hear today can be easily imported over there. Just as it could be sexual harassment to tell sexual jokes in the workplace, it could be racial harassment to tell racial jokes, use racial epithets in the workplace, okay? So this is the underpinning of the federal law, complete with the 1964 use of his. So the idea is that when you harass someone in the workplace, and when you're, as an employer, permit someone to be harassed based on their gender, you're discriminating against them based on their gender. Now here's California law, which the legislature, in its wisdom, has decided I need to give to you in its entirety on a PowerPoint slide because they hate me. So California says harassment on the basis of sex is an unwelcome sexual advance, request for sexual favors, or other verbal or physical conduct of sexual nature when submission to such conduct is made explicitly or implicitly a term or condition of the individual's employment. And that is quid pro quo. Or submission to a rejection is used as the basis for decisions affecting the individual, quid pro quo. Or the conduct has a purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment, hostile environment. So this California law just spells out these two doctrines of sexual harassment, quid pro quo and hostile environment. We're going to get into minute detail in all of that. Now, here's the question. Who is protected by the law? Who gets to bring a sexual harassment claim? Employees, obviously, whether you're full-time or part-time. Independent contractors are protected. How about interns? What do you think? Yes, I'm glad you assumed yes. The answer is a little more complicated. Under federal law, they're not protected. This is not a suggestion. This is, and under California law, interns are protected. So you're going to see a number of situations like this where something may not be illegal under federal law, but it's illegal under California law, so don't do it anyway. Yes?
Is that an intentional omission on the federal part, or just there weren't a lot of interns coming to mind?
I don't think they contemplated it in 1964 when they passed the law. Since then, they have not updated it in many ways. You're going to hear some other ways where it's currently in flux and controversial. Whereas, again, California legislature and courts are generally considerably more aggressive in how they interpret these laws, and they have said specifically interns, unpaid people are protected. The federal courts have said this is about employment and about earning a living, and that was the basis of the Civil Rights Act, so merely being an intern is not protected. I don't know if that makes a lot of sense, but the law is the law. Okay, so no harassing anyone, basically. Interns, independent contractors, employees. Remedies. One of the things you need to know are what are the remedies if you feel that you have experienced sexual harassment. You can file a lawsuit under the Civil Rights Act, federal law. That's only against the employer, not against individuals. It's for monetary damages and cease and desist orders. So you can sue your employer, you can get an order from the court for them to stop doing whatever they're doing, and you can get money. Under state law, the Fair Employment and Housing Act, it can be against the employer and individual employees who are doing the harassment. And again, monetary damages and cease and desist orders. So a typical sexual harassment complaint that I see, whether I'm representing someone who's been harassed or representing a business that's been sued, is going to have both, okay? And the federal one's going to be against the employer, and the state one is going to specifically name the individuals that the plaintiff says were involved in doing the harassing. So expect, the whole kitchen sink in any case. There are more remedies for sexual harassment, ways for people who feel they've been harassed to get some sort of justice. Those include other civil remedies, what we call the common law, things not from statute but from long-standing law. Assault and battery, sometimes. Defamation claims if someone is spreading rumors about you in the workplace. Intentional infliction of emotional distress, a claim that you can bring if someone has done truly outrageous things that would extremely traumatize anybody. And there can be criminal remedies, and sometimes these cases do go criminal. It can be anywhere from assault and battery to stalking, to rape, to false imprisonment. These obviously are situations where things have gone very, very badly. So, that's the general outline. Let's talk about the specifics. Let's talk about the first category, which is quid pro quo harassment. Unlawful quid pro quo harassment is when a manager or supervisor inflicts an unwelcome sexual advance, request, or course of conduct against the victim, and the manager or supervisor indicates, explicitly or implicitly, that some term of employment depends on how they react to that advance, or the reaction to the advance is actually used as an excuse for some sort of negative impact on the employee. Okay? So the key elements there are the manager or supervisor, it's unwelcome to the person receiving it, and either they suggest that you better do this or it's going to go bad for you, or they actually inflict some sort of consequence. So here's some examples of things that can't be conditioned. The boss can't say do this or else don't get a promotion or anything like that. So any tangible employment action, that's extremely broad. Keeping your job, getting a raise or promotion, getting a new or different assignment with significantly different responsibilities, significant change in benefits. The bottom line is this: there are a number of defenses that anyone has when they're sued for sexual harassment. And I always tell people, you don't want your defense to be, okay, yes, but the thing I threatened to do isn't really significant. You know, I only threatened to move them from this room to the other room, and that's not really significant. I'm just saying, I don't want to be standing up making that argument for you. That's not a great appealing argument. So, what do you think? Can you be guilty of unlawful sexual harassment of an employee under a quid pro quo theory if you make an advance on somebody, even if you're not in their direct report chain, even if you're not on the org chart directly above them? What do you think? Yes. So, if a reasonable person would think that you have influence over the employment conditions, you can be found liable even if you don't actually have that power. So if you're a supervisor, even if you're a supervisor in a different department, there's a substantial chance that your advance, if you make that threat, is going to be treated as quid pro quo harassment. The reasonable person test is determined from the perspective of the employee. So not someone who understands every nuance of the org chart or exactly what the supervisor's duties are, but the reasonable person getting this threat. Okay? So you can see again, this is one of the bad arguments I don't want to have to make. Well, actually, Your Honor, if you look at this chart, you can see that the defendant is, wait, no, I don't want to do that. When will the supervisor's actions be interpreted as illegal quid pro quo? Is the supervisor's behavior safe, do you think, if they don't explicitly condition your job on sexual favors?
It's implied.
Correct. It can be explicit or implicit. If a reasonable woman or reasonable man in the same position, and the law does consider that men and women may have different perspectives about this, would interpret a comment as linking employment benefits to sex, the comment is harassment. I used to have little video vignettes in here that I did using junior associates and paralegals. Problem was it really got a little too much into it, and they were just hitting their lines a little too hard, and the messaging was just not quite right. You know, it was not so much getting an impression sexual harassment is bad as sexual harassment is hilarious, which is really not the look I was looking for. So, there has to be some sort of nexus, though. So, there's a not too long ago case over at Caltech where a supervising professor made an advance on, I think, a teaching assistant. She turned it down, and 6 months later, there was some sort of position that she didn't get. And there was no evidence that there was a connection between those things. There was no nexus. So, not every case where an employer makes some advance on someone means that nothing bad can ever happen ever again to the employee. But, because of the way this works, if you're a supervisor or employer and you ask a subordinate person out, then for the rest of that person's time at your workplace, you should assume that if you ever discipline them that you're going to be dealing with this, which is why different level workplace relationships are fraught with danger. Sexual favoritism. What if a boss is harassing you? What if a boss isn't harassing you or making demands to you, but is giving preferential treatment to someone they're dating? Is that prohibited? What do you think? It can be. So, sexual favoritism, giving better employment treatment to someone that the boss is dating, can create a hostile work environment under some circumstances if it's widespread. It can also contribute to a quid pro quo case because, when you're interpreting what did the boss mean by that comment, was that an implicit demand for sexual favors in response to a benefit? Then a court is going to look at, well, what happened to other people? Other people who did date the boss got preferential treatment. Okay, that's the way I'm going to interpret this comment. So, very dangerous. Unwelcome. Now, this is a big one in both quid pro quo and hostile work environment cases because workplace relationships happen. Some of them are consensual. Some of them lead to wonderful lifetime relationships, and that's fine. Many people meet a spouse at work or in connection with work. That's not inherently illegal. But how do you determine what's unwelcome? It's determined from the complaining witness's perspective, whether it's unwelcome. Now, this is important because, help me out here, maybe some people aren't always perfect at knowing when their advances are welcome or not. Maybe some people have some processing issues with that entire concept. Maybe some people cannot comprehend that their advances would not be welcomed. Nevertheless, it's always best in this situation when you're thinking about how to make sure I don't have to deal with this in the workplace, to make the response to an advance that's unwelcome clear and unequivocal. Say, no thank you, I don't date people from the workplace, no thank you, I don't have a relationship, whatever it is. And this is not just me, the middle-aged guy, saying that. That's the EEOC saying it. The Equal Employment Opportunity Commission says, generally victims are well advised to assert their right to a workplace free of harassment. So say no clearly. On the other hand, the much more necessary and complicated message is that people who decide to make an advance on someone in the workplace, and it doesn't have to be something grotesque, it could just be asking someone on a date, right? You have to learn to take the no very early. So if you might be a little more persistent elsewhere, you need to take the slightest hint of a no in the workplace. And this is not as easy as it sounds, because our culture is absolutely terrible at this, right? What is the primary message our culture says about dating? In a romantic comedy, on TV, it's persistence, right? It's that sooner or later, the guy who is usually swinging way above his weight class is going to persuade this woman of how completely awesome he is by persistence. She's going to recognize, wow, he really is great. They're all written by middle-aged guys who look like me, so you can understand how maybe it comes out that way. But so the one I always use is, if you remember the John Cusack movie Say Anything, and there he's trying to win back this girl, and he's standing in her driveway with a boom box over his head, because it's 1980 something, holding out, playing music at her, and everyone's thinking, oh, that's so sweet, and all the employment lawyers in the audience are thinking, wow, I could buy a beach house. What I can make out of that? Because that type of persistence is a problem in the workplace. There's The Onion is a satirical newspaper, mostly online now, and they had an article entitled "Romantic Comedy Behavior Gets Man Arrested," which is true. Most of the behavior you see in a romantic comedy or in a sitcom that is portrayed as amusing, romantic persistence will get you arrested in the real world. So, the bottom line to all of this is, I'm not going to tell you how you live your life out of work, but at work, take the no, take it early, take it immediately. All right? So workplace sexual advances are risky. They're risky even if you're pretty confident this person likes you. They're risky even if initially they're welcome. They're risky because there's always going to be a one person said this, the other person said that. There's usually not going to be witnesses unless you're really bold. And there's going to be a difference of perception in how it works, right? There's going to be an appearance of impropriety. And there's going to be an appearance of connection to later problems. So I can't tell you how many times I've seen cases where there was a consensual relationship, it broke up, as many relationships do, and then some period of time later, the employee who's complaining got into some sort of trouble at work, they were disciplined, there was reason for the discipline, but their assertion is that the real reason you're disciplining me is that I broke up with you, all right? And that's a huge kettle of fish. The employer might eventually win that and might convince a judge or a jury that yes, in fact, this person did do something wrong, so it's appropriate to discipline them, but you just made that case much more expensive and much harder to defend. Okay. By the way, you should feel free to stop me with questions throughout this. Sorry, I should have said that earlier. Okay. The threat, the quid pro quo threat, standing on its own, is illegal. Doesn't matter if you carry through. Okay? So, if you say, I think you really should consider going out with me, you've got a performance review coming up, it doesn't matter what happens if they say no and you still give them a stellar performance review. The mere threat is sexual harassment, all right? Okay, that's quid pro quo, relatively straightforward. It's a bright line that even the 5% can perceive and on some level appreciate, all right? Let's talk about hostile environment harassment. Considerably more complicated, considerably more anxiety-provoking for a lot of people, more controversial in the culture. But what I'm going to suggest to you is it doesn't need to be, it shouldn't be, and it's actually pretty straightforward. And I think you'll come out of this saying most of what I heard about this is exaggerated. Okay. Hostile work environment is complicated. It has a lot of factors. And one of the things you'll see is that despite cultural messages that it's ridiculously easy, and this is usually men complaining about this, for a woman to make a sexual harassment complaint, and anyone can make it and bring a lawsuit and get money. It's actually really hard to bring a successful sexual harassment lawsuit. There are a lot of requirements. Few of them succeed. So, there's a hostile work environment when someone engages in harassing conduct, the victim is the target or perceives it, so they see what's happening where it's done to them. It's based on gender. There's that discrimination again, based on gender. The harasser was a manager or supervisor, or they were not a manager or supervisor, but the employer didn't manage the situation, didn't take reasonable steps to prevent it, and the conduct was unwelcome, and it was so severe or pervasive that it had the purpose or effect of altering the conditions of the work environment and created a hostile environment. And a reasonable person in the same circumstances would find it that extreme, and the victim actually saw it as extreme. It's a lot of factors, right? All of a sudden you think, wow, you've got to jump through all those hoops to show sexual harassment. All of a sudden you don't think, well, it's easy, anyone can do it. That doesn't mean, by the way, oh, okay, I'm pretty much in the clear here, I'm not worried anymore. No. there's still a series of things you can think about and do to treat people decently in the workplace. This is just to show you how complicated the requirements actually are. Let's start by talking about the difference legally between supervisors and non-supervisors. Okay. Door of Hope, like any employer, is automatically on the hook for conduct by a manager or supervisor. If a manager or supervisor engages in harassment, then Door of Hope is liable for it. And for non-supervisors, for fellow employees, for anyone all the way down to an intern, Door of Hope is responsible for someone's conduct if it knew about the harassment and failed to address it, if it didn't have the required policies and training, and then it could be responsible for that individual. So you see why training is important. You see why reacting the right way to a harassment complaint is important. Because if you have a situation where a lying employee engages in inappropriate conduct, the person who's the victim makes a complaint, and the employer reacts swiftly, appropriately, professionally, and handles the situation, they're not liable. And so not only does that mean they can't be successfully sued, it means they probably won't be sued at all, because lawyers will know that there's probably not a problem there. Yes?
Two categories come to mind that you haven't touched base on. This might be a different law, but one is clients,
Yes.
and one is volunteers. So
Okay, are you talking about, I would get to both of those. Do you mean as harassers or as victims or both?
Victims.
Okay, so Title VII in California law, these laws cover people in certain relationships. The key relationship is the employer-employee one. So harassing clients would probably not be a violation of this set of laws. It would not be workplace sexual harassment. However, it would be extremely hazardous under other areas of California law. So there's a broad anti-discrimination law in California that prohibits harassment and discrimination by any number of organizations, and that is something probably that a client, someone who wants to be helped by Door of Hope, could invoke if they felt they had been sexually harassed. Volunteers who are volunteering for Door of Hope would probably fall into the intern category that I mentioned. So not being paid, but under California law, they are working for Door of Hope. They are not an employee, but they are like an employee, so don't harass them.
Good question.
Hand will come back to you.
What about the reverse, where one of our residents is harassing one of our employees?
Good question. I'm going to get to it shortly. Okay?
That was my question.
Okay. I'm going to get to that shortly, I promise. So the bottom line is an effective training, effective policy, reacting the right way protects the organization, even if an employee has done something wrong. An employer defense for supervisor conduct, even if a supervisor is misbehaving, Door of Hope can still protect itself if the employee didn't suffer any tangible employment action and the employer exercised reasonable care to prevent and promptly correct the harassment. So let's say a supervisor engages in some inappropriate workplace conduct that's over the line. If they didn't actually inflict fire somebody or demote them or something like that, or discipline them, and if the employer immediately takes care of it, then that rule about how the supervisor, you're automatically on the hook, you have defense to that. So again, you see the importance of the training, the procedure of doing things the right way.
Can I ask you a question?
Yes.
About hostile environment. You said it has to be clear that it's unwelcome or for the employee. So I've been in situations, all male work environment, and they make a lot of jokes, comments on your appearance, and you're clearly uncomfortable, but you feel so uncomfortable you can't say anything. Would that still fall under that? You know, if you're not verbally saying this makes me uncomfortable.
It could be harassment, but if you don't do something about it, your remedies and your rights could be limited. And I'll get more into that, okay? And by the way, it's perfect fine. People always ask me questions jumping ahead a bit. I will get to it. If I don't get to it, then you can ask me more. Another one, if an employee unreasonably fails to take advantage of preventive or corrective opportunities. So, if you go to the training, you're told, okay, if you feel you've been harassed, this is who you go to. You feel you've been harassed by a supervisor, you don't report it through the report chain, you never tell anybody, and a couple of years later you sue, you're probably not going to be able to prevail, even if that was a supervisor harassing, because they gave you this clear blueprint of what you have to do, and you didn't give the employer an opportunity to correct the behavior. All this is about not just let's make things right for people who have been wronged, but it's also about let's encourage behavior that as a whole works to prevent and stop harassment. So the law is set up to encourage you to take that step, to talk to somebody even if you're not comfortable talking to somebody. Okay? Who's the victim? What conduct is directed at a particular person? Can that person complain about the harassment? For instance, let's say someone's sitting nearby and the people there are telling jokes, and they're not telling jokes at you or directing comments at you, but you're perceiving it. Can that be sexual harassment? Yes, it can be. So the victim of sexual harassment can be a direct target, even if it's not directed at the victim, if it's not directed at anyone in particular. Examples of this could be pornography posted in the workplace, sexual or demeaning discussions, that sort of thing. This is another one where I had a video and I had two of my associates pretending to be dudes in the workplace having an inappropriate discussion in front of the paralegal at the reception desk. And again, they were just too into it, didn't come out, tone wasn't quite right, so I ditched it. So the classic example is very much the one you said, where people are in the workplace are telling jokes, having inappropriate discussions, that type of thing. And we'll get into examples of that, but someone who is merely having to sit there listening to it can be a victim of sexual harassment. Okay? Is sexual harassment limited to the workplace? So, if someone harasses you outside of work, can you report that? What do you think? I'm hearing, that's not an answer. Yes. So, here's the rule. If an employee is at a function that's work-related, it's the equivalent of workplace sexual harassment. So, if someone harasses you at the sexual harassment training, a prospect that I once would have dismissed as ridiculous, and I no longer do, you would report that. If you had a company picnic, if you had a company event of any sort, a retreat, something like that, that is the functional equivalent of the workplace. There are sometimes gray areas. So, the classic example, again, particularly in a sort of male-dominated work culture, is that everyone tends to go out for drinks on Friday after work, and a lot of talk about the business winds up happening then, but is it really work-related? Well, if I'm the plaintiff's lawyer, I'll make it work-related. I'll win then. If it's something that routinely happens with people from the workplace, where they routinely do it outside and they talk about work activities. So the rule of thumb I use is, aside from trying not to harass anyone, please, in any situation, is that if you're with coworkers, you should consider there is a significant risk that it will be treated as work-related. Okay? Harassment by third parties. So, should you report sexual harassment by people who aren't Door of Hope employees or interns or independent contractors? Delivery people, clients, anything like that. What do you think? Yes. Your employer has a duty, a legal duty, to prevent a hostile work environment, and that includes taking reasonable steps to protect you from harassment by third parties, from clients. So, again, the classic case is the UPS guy hitting on the receptionist, right? But in situations like this, or in churches, or in schools, it can be incredibly difficult and sensitive. I mean, what do you do when a parishioner is is making inappropriate comments to someone on the pastoral staff at a church? What do you do if a parent of a child in a school is making inappropriate comments to a teacher? It can be really very fraught with problems, which fortunately for almost all of you, it's not going to be your problem. Sorry. It's going to be the problem of the people running the investigations. But there is an obligation to protect you as an employee from outsiders, from clients, from customers, from service providers, anyone out there from treating you badly. You have a right not to be harassed in the course of your work. And that right includes an obligation on your employer to do something about it. Again, tricky for a lot of organizations where there is a sort of a different type of relationship with a customer, where it's not merely a economic relationship, but a pastoral or a teaching one. Okay, types of hostile work environment. Here are the basic categories, and then we're going to go into them. There's verbal, which is saying things or writing things. Physical, touching or threatening to touch. Visual, pornography, pictures, cartoons, notes. Conduct, bullying, singling out, things like that. Those are the main categories that we deal with. Most hostile work environment complaints describe conduct falling into one of those categories. So, when we're talking about this stuff, when we're determining whether or not harassment is so severe or pervasive that it alters the effect of your workplace and makes a hostile environment, what do you think? Are we going to look on a case-by-case basis? Is this enough? Is this enough? Is this enough? Or are we going to look at all of it at once? Sure.
Going back to the third party, what if that child, that person that commits the harassment is a child?
It doesn't matter if it's a child. Your employer still has an obligation to protect you. Now, what they do to protect you might reasonably change with the identity of the person who's making the inappropriate conduct. So with a child, the employer's reasonable approach might be to talk to the child's parent and make an effort to make sure it doesn't happen again. But it could be all the way up to, making sure you don't have to deal with that person again, protecting you from that person. It could even at some point require taking that person out of the program, removing them as someone that you're giving services to. All right, back to this. We're looking at something, you've accused someone of sexual harassment. How are we going to do it? Are we going to go, okay, was this joke bad enough? Was this joke bad enough? Was this incident bad enough? Or are we going to put it all together and look at it once? Exactly. It's called the totality of the circumstances. The question is whether all the conduct complained of, taken together, creates a hostile work environment. Now, this is both a risk and a defense, if you think about it. So on the one hand, you can't get away with constantly just going barely over the line, right? You can't get away with just constantly, it's like the kid brother or sister saying, I'm not touching you, I'm not touching you, I'm not touching you, coming up to that line constantly. Sooner or later, they're going to look at all the conduct together and decide whether when you cram it all together, whether that creates a hostile work environment, taken as a whole. On the other hand, this is why you don't have to be panicked that you, as a human being, occasionally says something inappropriate. You had a bad day, it was an error of judgment, it came out of your mouth and you realized after it came out, oh my God, I didn't mean to say that. You don't have to be panicked about that because they're going to look at the totality of the circumstances. They're going to say, okay, what was this relation like over the long term? Is this a workplace where those sorts of comments were constantly being made? Or did someone say that thing at one time and in the totality it was not terrible? So that's why you don't have to panic when you, like any other human being, occasionally say things that you realize were inappropriate. Or maybe even have a weak moment and deliberately say something inappropriate, because none of us are perfect. So It's the totality of the circumstances. So let's talk about verbal sexual harassment. So here are examples of things that are going to be looked at to see whether they're severe or pervasive enough to be sexual harassment. These are things that potentially qualify. Sexual advances, suggestions, and requests. Comments about an employee's body or appearance. Comments or questions about an employee's sexual habits or relationships or history. Telling stories or spreading rumors about an employee's sexual habits or sexual history. Comments about an employee's sexual preference. Slurs and name-calling along gender lines, just as slurs or name-calling along racial lines would be racial harassment. And pet names, if sexual or gender-based. Sweetie, honey, etc. Here's some more verbal examples. Sexual or dirty jokes, jokes about gender, men jokes, women jokes, blonde jokes, so forth. Derogatory statements generalizing people based on gender. Women can't do that job, men don't think, men don't ask for directions, etc. Sexual propositions and advances. Whistling and catcalling. I'm thinking hopefully that's not a huge problem for you guys. All those things. So again, sometimes people look at this and say, oh gosh, I can think of like 2 of those I might have done as a joke sometime in the last 5 years. Totality of the circumstances, okay? Is it severe or pervasive? Severe meaning, is it one incident that makes your jaw drop? Or is it pervasive? Does it happen all the time? So it changes the nature of someone's workplace. Just kidding. If you didn't mean to be offensive or harass, if you were kidding, if you thought they would find it funny, if other people had found it funny, if some of the people present did find it funny, can it still be harassment? Yes, it can. Because the standard is not about the intent of the person engaged in the conduct. It's not about what's in their head. It's about the reaction. There's a component of what lawyers call objective reasonableness. So you're going to ask, would a reasonable person find that truly offensive? So offensive that it changes the nature of the workplace. But there's also a subjective component. Did this person experiencing it actually find it offensive? So again, the objective component is why it's not true that anyone can successfully sue for anything. You will see purely ridiculous lawsuits where someone says something that 99% of humanity would think is inoffensive and not a gender reference at all. This person found it offensive for internal reasons. That's not sexual harassment. It has to be both subjectively offensive to that person and objectively offensive to a reasonable person in this circumstance. Here's some examples of bad verbal conduct that have resulted in liability. This will give you a bit of a sense of how bad it has to be before it's someone who sues successfully and wins for sexual harassment. An employee bragging about sleeping with a coworker. An employee talking to a coworker in public with other people about having a sexual dream about them. An employee repeatedly asking a coworker about her sex life and talking about his own sex life. An employee refusing to use a coworker's name, but calling her honey, sweetie, cutie, etc. And this is in part, I think, a generational thing, but that it would have to go on for a while over the person's objection to be the part where it's going to be sexual harassment. An employee rating coworkers' desirability over the corporate email system, which is some people's children. Repeatedly asking for a date after being told no. So those are all examples of things that are going to be bad enough, potentially, to be sexual harassment. More examples. Mocking coworkers' clothing and appearance along gender lines. Why you dress like a girl, something like that. Employee addressing coworkers with obscene and insulting epithets. Repeatedly talking about their own sexual exploits. Repeatedly making sexual references and jokes in conversation. Again, it's a rule of look at it all together. If someone once made a "that's what she said" comment in a conversation, that's not going to be sexual harassment. If they cannot engage in a conversation without a sexual comment, that eventually can be a hostile work environment.
I have a question. What are epithets?
Epithets. Swear words, like racial slurs, gender slurs, that type of thing, okay? So bitch as a word, probably if you drop it once in the conversation is not going to be sexual harassment. If you routinely demean people in your workplace using that word, that's going to get there. Visual sexual harassment, pornography in the workplace, less than pornographic pictures. So, Maxim magazine or something that people even older than me would call cheesecake pictures. Printed material that would be harassment if you said it aloud or in person. Sexual or gender joke emails, cartoons, and flyers. Staring or leering repeatedly. Sexual gestures. I met a new pastor one time by giving this presentation. It was the first time I met him, and having him ask me, what do you mean by a sexual gesture? And I was thinking, I really did not anticipate in law school that this is the way my career would go. I did not provide examples. I insisted that he needed to use his imagination. Here's an example, prolonged staring. A company and employee with it faced grave consequences when the employee did the following after another employee turned out his request for a date. He walked past her workstation unnecessarily 5 to 10 times per day, and he went out of his way to stare at her for lengthy periods of time during that. So do you see how, if you say, oh, this one time this guy was looking at me, how they're not going to make a sexual harassment case out of that, but if someone really is harassing you in the workplace, making your workplace different, that's going to rise to the level. This is an example. This went on, it was pervasive. What about when conduct is not overtly sexual? If something isn't overtly sexual or gender-based, but it bothers you, can you report it? Yes. Conduct like staring at your body, unprofessional pet names, sweet dear honey, and unwelcome touching can be sexual harassment, can be reported, even if they are not overtly sexual, but you might experience them that way. Remember, sexual harassment law, even though it has the title sex, it's using sex in the sense of gender. It's discrimination. Are you being treated differently because you're a man or a woman? If you are, if that is the basis of this conduct that's making you uncomfortable, that can be sexual harassment. It does not have to be about copulation, for want of a better word, okay? Physical sexual harassment can constitute unwelcome touching. Handshakes are acceptable, almost universally in our culture. I mean, sexual harassment law is partially culture-based, because we're going to ask, would a reasonable person find this offensive? And the reasonable person is going to be a reasonable person in this culture. There are some religious communities in which it would be inappropriate for me to shake a woman's hand unless I was married to her. In that culture, it might be harassing for me to do so. In the wider culture, it won't be. Groping, copying, feel, grabbing, obviously inappropriate. Dangerous, hugging, kissing, or other touching. This one sometimes I get pushback on. Some people are huggers, right? And I rarely find a hugger who I think means ill or who's doing it for sexual reasons. A lot of people are just part of a family culture or a personal culture where that sort of display of affection is normal, anticipated, nothing is meant by it. So I speak on behalf of all the shy and repressed people not comfortable with other human beings and say, give us a break. Not everyone likes to be hugged, all right? And sorry, you got to deal with that. On the other hand, if you're someone who doesn't like to be hugged, you need to make it reasonably clear by your behavior that you prefer not to be hugged, which can be done by a very big step back, which is my typical stance. Again, it doesn't matter if you mean well. Most people mean well, or they think they mean well. It matters how it makes the person feel and how a reasonable person would react. So, you could have, great Aunt Gladys who has always hugged everyone, and whose grandmother always hugged everyone, and, doesn't mean it sexually at all. but if she keeps doing it when it's unwelcome, that can eventually rise to the level of workplace sexual harassment she does in the workplace. No offense to any graded classes. Assault, obviously, is physical sexual harassment. Physical blocking and pushing. Oh, let me talk about one of these. A danger zone item. Never block an employee, whether you're a supervisor or not, into a space. Never deny people an exit from a physical situation. One of the most common mistakes I see in sexual harassment employment cases is employers like call the employee in, bring them in the room, shut the door, start interrogating them or berating them, and like stand in front of the door so they can't get out. I mean, to tell you, that can be, believe it or not, kidnapping. If you block someone in physically to a situation so they are unable to leave, that can technically be kidnapping. It can certainly be a civil claim, and it can absolutely be sexual harassment. Never, never, never block someone into a situation where they can't physically exit it if they want to. Here's an example of bad physical behavior that never fails to blow people away. Company faced liability when the supervisors forced employees to engage in a team building exercise that involved the supervisor spanking the employees while coworkers shouted, "Make sure she feels it," and spank her hard.
What?
Corporate icebreakers, what can I tell you? The court explained that such conduct, viewed from the perspective of a reasonable woman, or I would say from any reasonable human being, was humiliating and inappropriate. That's an example of severe, right? Remember how harassment has to be either severe or pervasive? Either really, really bad or not so bad that happens a lot over time. That one's severe. We can all agree on that? No spanking machines. Can you promise me I never have to come back and clarify the spanking machine? Thank you. It's like as I come out of this and everyone knows no spanking machines, no nudist colonies, I feel like I've made some progress. Conduct-based sexual harassment. Sexually charged pranks. Stripograms, locker filled with blown up condoms, what have you. Sexual favoritism, which we talked about before. People who engage in relationships with the supervisor get preferential treatment. Sexually themed events or locations. No strip clubs, no Hooters, no anything where you would not want to stand up in church and say, "We did our team building exercise at," and there it is, okay? No strippers, no strip clubs, gender-based bullying. So even again, it's not overtly sexual in nature, it is referring to sexual relationships. If it's based on gender, it's discrimination. Singling out or shouting or other abuse based on gender is sexual harassment. Yeah. Okay. When is harassment sexual? Can harassment be sexual if it isn't based on sexual attraction or sexual issues, using sexual there in the sexual relationship sense and not the gender sense? What do you think? Yes, absolutely. Because if it's based on discrimination against someone based on their gender, it's harassment. Non-sexual conduct, non-sexual in the sense of not about sexual relationships, is harassment if it's directed at someone in a discriminatory way because of their gender. Emerging issues here, it's been the law for at least almost a generation that you can sexually harass people based on their sexual identity, based on them being gay or lesbian. The concept is basically that you are treating them differently because of their gender. You have this idea in your head that men date women, and therefore if this is a person who is a man dating a man or a woman dating a woman, they are deviating from your view on what gender does, and therefore if you harass them based on that, that is gender-based discrimination. There's actually a case in front of the United States Supreme Court about this right now, over whether federal law extends to this, even though the courts have generally assumed that it does for the last half generation at least. And the woman making the argument for the plaintiffs, I thought was brilliant, and her example to the court basically is if someone comes in tomorrow and says they were married over the weekend, and you congratulate them if it's a man who married a woman, and you harass them if it's a man who married a man, you're treating them differently based on gender. So that's the concept here. So one of the things that happens that winds up being sexual harassment that people don't anticipate is bullying, particularly male-on-male bullying, along lines that someone is perceived to be gay or treated, ridiculed or bullied along the lines that we think you're gay, anything like that. Sexual harassment, because it's different treatment based on gender. So, gender-based signaling out. There was a case that I actually worked in. The police department, police officers and supervisors in the city got in real trouble when they did a follow to a female officer, one of the first female ranking officers in the department's history. They spread untrue rumors about her abilities. They filed unsubstantiated reports about her job performance. They singled her out for unfavorable job assignments. And they played pranks like stuffing her shotgun with paper. Now, none of that is overtly sexual in the sexual relationship sense, right? But it's gender discrimination. They were treating her differently because of her gender. So that makes it sexual harassment. There is a classic Law and Order episode from like one of the first seasons, which makes it, I guess, like 30 years ago, where a bad police department doesn't give a cop backup and doesn't show up when he calls for backup during a shooting because he's gay, it turns out. That is sexual harassment. That is gender-based discrimination. You have an image of what this person should be based on their gender, and because they deviate from that image, you treat them differently in the workplace, even if it's not in a sexual way. If it's about gender, if it's treating people differently, it's sexual harassment. Okay, belittling and undermining. So this is something that comes up sometimes. Gender-based conduct that undermines an employee's duty to do their job can be sexual harassment. Again, even if it's not overtly sexual. Singling out someone for mockery or questioning or belittling in front of customers, clients, whatever you call them. Undermining someone based on gender. Refusing to give them backup or assistance. Anything like that. Again, all that conduct, if you treat someone differently based on gender, can be harassment. So when is harassment sexual? We kind of really discovered this. It's harassment for a straight person to tease someone about being gay. Yes, it is. Because that is gender discrimination. It is saying, you are a man or a woman. A man or a woman acts like this. I don't think you act like that. Therefore, I'm going to treat you differently. Gender discrimination. So the difference here is a lot of people figure, well, it's not sexually harassment if I'm not into this person, right? They have this idea that sexual harassment is like unwelcome advances. You want to have a sexual relationship with this person. It's not it at all. It keeps coming back to discrimination. Harassment is gender-based, even when it's not premised on sexual harassment. Again, the key is discrimination because of gender. Would the conduct have been the same if the gender had been different? Would you have congratulated that person for their wedding over the weekend if it was a man instead of a woman, instead of harassing them? It's the same thing with sexual stereotypes. So stuff about how you're doing things that I don't think that men normally do or women normally do. So like when my mother-in-law, when my wife is away and my mother-in-law calls and says, oh, you're babysitting today. I'm like, no, I'm parenting. That's what it calls when you're a parent and you're taking care of the kids, not babysitting. I cannot technically sue my mother-in-law for that, but I probably wouldn't. But that's an example. You have these stereotypes in your head of the way men and women act, and you treat people differently based on those stereotypes. That can be sexual harassment. So, right now, the United States Supreme Court is considering whether Title VII of the Civil Rights Act, that law that you said that you can't discriminate based on race or sex, whether that does cover people who are harassed because they are gay, whether it does cover people who are harassed because they are transgender. And the fundamental legal argument at play there is, do we decide this based on what Congress thought about it in 1964? Congress wasn't thinking about gay people or transgender people in 1964, wouldn't have wanted to protect them. Or do we look at this as sort of an emergent understanding of this language over time? How we come to treat people differently and protect them. That is a legal theoretical dispute that you do not need to engage in, because I'm here to tell you that however the Supreme Court rules, California law unequivocally protects people based on being gay or lesbian, based on their gender identity, whether they identify as male or woman or male or female or anything else, unequivocally protects them from discrimination on that basis. So even if the Supreme Court goes the other way, and I don't know which way it's going to go, the way you have to act is the same. You can't treat people differently because they're gay or lesbian or straight, or because they are transgender, they identify as different than they appear, anything like that. Now, not all behavior that's bad is sexual harassment. Bullying, harassment, or other bad behavior isn't sexual harassment if it's not targeted at someone because of gender. It can be racial harassment, it can be religious harassment, but if it's just because the person's a jerk, then that's not sexual harassment. I deal with a fair number of prospective clients who call me and say, my supervisor did this, and this, and I think they sound like a complete jerk, but I'm not hearing that anything is based on your gender, your race, because you reported misconduct, anything like that. That's not illegal. California, like most states, is an at-will state. That means that unless you have a contract saying otherwise, you can be fired for any reason that's not specifically prohibited by the law. So a lot of bad behavior is not prohibited. But Door of Hope does not want you to engage in them. Any reasonable employer does not want you to engage in it. So you shouldn't feel just because this thing is making me feel bad, that's changing the way I feel about my job. You shouldn't feel because it's not sexual harassment, you shouldn't report it. You should. And in fact, I've seen it. Door of Hope has a great, extensive employee grievance policy, and I'm not talking about today, for non-sexual harassment matters, that really reflects a concern about smoothing out these issues and addressing them in an appropriate way. So some people get to this part and say, I'm terrified, anything I say or do can be sexual harassment. These are people mostly who are not listening. So sexual harassment law is not a general civility code. That's the way the courts call it. It's not generally a statement, you have to act this way. It doesn't cover simple non-sexual teasing, offhand comments, isolated incidents that aren't extremely serious or pervasive. But remember, if things treat people badly, if it changes their workplace, then it is against the policy of Door of Hope, even if it's not illegal. There are some things that I call red line items, okay? Where if you see this, you know it's serious, important, it's much more likely to cross the line into sexual harassment. It's much more likely to be severe, maybe in addition to pervasive. Forcible physical contact. Any groping, grabbing, striking, anything like that. Vulnerable circumstances. Hitting on someone forcefully while you're away at a conference in a hotel room. Something where someone can't easily exit the situation, or where there's a power imbalance or a feeling of vulnerability. Severe behavior, really extreme things that, like the spanking machine, where everyone immediately says, oh my gosh, that's terrible. Repeated behavior, right? Something that keeps happening, particularly after you've made it clear it's unwelcome. Behavior calculated to be demeaning or humiliating. If they mean it to humiliate you and put you down, then it's much more dangerous and likely to be harassment. And significant age and power disparities. And power disparities including supervisors and coworkers. Here's some examples of sufficiently severe or pervasive conduct that cross the line. A lot of times what happens in a lawsuit is that you take some initial discovery, you take depositions, you ask questions, and then there's something called a motion for summary judgment, which is basically a way to argue with the court. Even if all this evidence is true, that's not enough to be sexual harassment. And so there's lots of cases analyzing that, where the court says, this is what the evidence showed, and we find this was or wasn't enough to be severe or pervasive. So, over a 2-year period, a supervisor called the victim gorgeous and beautiful rather than by her name, told her his sexual fantasies about her, commented her body, and asked over a loudspeaker whether she needed help changing clothes. Pervasive. Okay? The loudspeaker thing might have been enough to be severe on its own. All of it was pervasive sexual harassment. In a single incident, a company president made repeated strong requests for sex in a hotel room at a convention. Sexual harassment. Severe. Vulnerable, right? The vulnerable circumstance, more likely to be over the red line. That was sexual harassment. The supervisor grabbed an employee, groped her, and continued to hold her after she screamed. Severe. Sexual harassment. Several times a week, often every day, a male waiter was referred to as she or her, addressed with sexual epithets, and mocked for walking like a woman. Pervasive. Maybe one of those things would not be enough, but pile them up over time. That's pervasive. It changes the nature of the workplace. Co-worker broke plaintiff's arm while directing gender-based epithets at her. Right? We know that's over the line, right? Severe. No breaking bones. Supervisor engaged in a public verbal tirade, accusing the plaintiff of getting into her office by performing a sex act on the supervisor. Severe, public, humiliating, calculated to humiliate, over the line, severe enough to be sexual harassment, even though it was just one incident. But here, on the other hand, are some insufficiently pervasive or severe examples. Over a short period of time, an employee called third parties rude and sexist names in the victim's presence. Not pervasive enough, not severe enough, not sexual harassment. Something that they should have been and probably were disciplined by the company for, but not enough to be legally sexually harassing. Supervisor and employees made sexist comments about sex roles and told dirty jokes to each other on sporadic occasions. Held, not sufficiently severe, and it wasn't sufficiently pervasive. Now I can tell you this one, if you played it out long enough, or if you upped the nature of the jokes and the comments enough, that would fall into sexual harassment, right? But this is what in a category that courts call isolated comments. So it's not enough to be severe or pervasive, to be sexual harassment that wins a lawsuit, even if it is and should be conduct that gets people disciplined in a workplace. The supervisor talked about how another employee was attractive. A single occasion wasn't done in horrible enough terms, wasn't pervasive, not sexual harassment. And finally, one of my favorites, the supervisor used terms like castrating, harpy, and Medea. Was not sufficiently pervasive, not sufficiently severe, unusually literate with a Medea reference. Definitely something the person should be counseled and disciplined for, but not enough to cause a successful sexual harassment case. A co-worker brushed the leg against somebody, slapped his buttock. On one occasion, made a few sexually based comments. I don't know if you're going to win that one every time, but that time it was not enough. Supervisor asked if a tube of lipstick was his, mentioned a gay club, performed a mock pole dance when the plaintiff was in the room. That was treated as not enough. Co-worker made comments about women's bodies and prostitutes in plaintiff's presence and referred to a diva squad. Maybe what you're getting from some of these, and this is what I intend, is wait a minute, I kind of think some of those should have crossed the line, right? So I'm not saying that to encourage you to think what you can get away with, right? I'm doing it to dispel this culturally broadcast message that why even bother because anything can be sexual harassment. People have this attitude that because anyone can spin anything, these terrible lawyers, they can take any incident, no matter how incident, and spin it into a sexual harassment case. Why should we even try? This is why. Because it's actually pretty hard to prevail in a sexual harassment case. So aside from the fact that maybe we should treat our fellow human beings decently, and because you're going to get fired if you don't, there's also the concept that you can actually train people and learn not to violate these rules, because you have to be pretty bad to conclusively make it sexual harassment.
What does the law say about firing an employee that exhibits any of these things that aren't legally sexual harassment, but that we would consider bad enough that we don't want that environment for our rest of our employees?
So, California is a at-will state, meaning you can fire people for any reason not prohibited by law, and that broadly is you can't fire them for race, gender, religion, sexual orientation. You can't fire them because they complained about harassment. You can't fire them because they reported wrongdoing. But you can absolutely do that. We're going to talk in a few minutes about investigations and discipline, but the bottom line is that so long as you conduct a good faith investigation that resembles what you would do if you genuinely cared what happened, you can absolutely fire people for that. Okay?
Question. 4
Yes.
or 5 slides back, there was this bullet point on like age and power disparity or something.
Yes.
Can you explain that?
Yeah, that was a red line issue. So it's more likely to be seen as severe or pervasive if you've got someone with more power harassing someone with less power. So if you've got I don't know, this is a hypothetical, President of the United States and an intern, that would be a big power experiment, right? If you've got the CEO of the company and an intern, the huge power disparity makes it much more likely that's going to be seen as harassment.
So the same
If you've got one corporate VP making inappropriate comments to another corporate VP, that's less likely to turn into severe pervasive harassment.
And so for the age thing, it's like if somebody's significantly older than.
Yes. It's mostly about the youth or vulnerability of the victim. So you've got an 18-year-old volunteer, that is at the maximum danger level. Okay? Any others before I keep going? Yes?
Is there like a general idea of when you say pervasive over time? What's the time frame?
It's a sliding scale with how bad it is. So generally, the less bad it is, the longer it has to go on. The more bad it is, the shorter it has to go on to be sexual harassment. So if it really is, a 80-year-old guy on the board who calls the receptionist honey, even though she doesn't like it, it's going to have to go on for quite a while after he's told to stop before it rises to the level of legally actionable sexual harassment. On the other hand, if it's, him making advances on her, then that's going to take a much shorter time because it's more objectively offensive, more likely a reasonable person would find that it changes the nature of the work environment. So it's not a bright line type of thing. It's a sliding scale. You adjust how bad is the conduct, and the worse it is, the less time it has to go on for.
And what if, like in the pervasive argument, there's no system in place for sexual harassment complaints? That's known.
You mean there's no way to report it?
Mm-hmm. That's
Well,
made known to the employee.
if there's no way to report it, then the employer is not fulfilling its duty to reasonably protect you from sexual harassment. So what I'll talk about is Door of Hope's policies and the way to report it. And there has to be that avenue. And when there is, that's part of a successful sexual harassment prevention program. Okay? I'll keep going. So sometimes you find yourself, does this cross the line or not? Well, remember that the court or investigators are going to look at the entire universe of conduct, not just 1 second at a time. But if you're asking yourself if this is over the line, ask yourself the question I ask my kids: is this helpful? Is it kind? Is it useful? Should I be doing it if I have serious questions about whether it's over the line? Religious organizations, explicitly religious organizations, have some special issues. Churches and religious organizations have a limited ministerial exception. What that means is that certain classes of employees can be required to have certain religious beliefs. So if you're a church, you can require somebody to have certain religious beliefs to put them in certain positions, what are called pastoral positions. So Door of Hope probably, on a policy-making level, would be able to allow people to share the organization's religious mission or religious beliefs. Could it require a secretary to have those beliefs? Probably not. That's probably not pastoral. So that might be prohibited discrimination. It's not clear whether this extends to sexual harassment law. Even though sexual harassment is premised on discrimination law, there are really no test cases on whether that means that a church or religious organization can invoke that as a defense to sexual harassment. I would just assume not litigate that test case. I think it's a terrible argument. I think it would be received very badly. Yes?
In terms of your distinction between the ministerial, pastoral, and the secretarial,
Right.
I'm aware of a case in World Vision, United States, where 3 employees who had professed faith lost that faith and very overtly proclaimed that and were fired as a result. And that case made it to the Supreme Court, which declined to, I don't think they declined to take the case, which meant that the lower court was upheld, which said that firing was legal. Is that related?
That's consistent because a pastoral employee, someone that a religious organization can on some level discriminate against, is someone whose job it is to communicate the religious values of the organization.
But these 3 were not in that position, to my knowledge.
I would have to look at the case to tell you how they got to that result, but I would suspect that the answer is that if the court came out saying that it was okay to fire them, that it was acceptable, it's probably because they were not in a position where they communicated the church's values. So at a religious school, a teacher is likely in a pastoral situation, a janitor is not. Okay? So it's always going to be a line drawing exercise, but the bottom line is probably is not something that's going to influence sexual harassment a lot. Certainly should not be. Don't be a test case. Okay. California wants me to tell you, which I'm happy to, that in addition there are issues with non-sexual bullying. That is conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to the employer's legitimate business interests. Abusive conduct can include repeated infliction of verbal abuse, derogatory remarks, insults, epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage or undermining of a person's work performance. A single act should not constitute abusive conduct unless especially severe or egregious. Note that it doesn't require it be based on gender or race or religion. The reason this is here is that the legislature heard a lot of stories about bullying in the workplace, and they thought we can change this by making everyone put a slide in their presentation. It really has very little to do with the law. Workplace bullying, not based on gender, is not sexual harassment. It could be other things. So if you bullied somebody in the workplace on any basis like that, that could be what's called constructive termination, which is that if your job conditions are so objectively terrible that a reasonable person would leave, it's the same as if they fired you wrongfully. It could be what's called intentional infliction of emotional distress, truly outrageous conduct towards a person that causes emotional harm. So this is just another reason why Door of Hope has already, pre-existing before this requirement, a very good standard about treating other people decently in the workplace, as do most workplaces. The other issue is that even if it's not based on gender, it is childishly simple if someone is acting extremely cruelly towards you to find a basis on which is prohibited. And there's going to be some characteristic you have, something you've done, where you're going to be able to say, this is the reason. And that's why it's always dangerous conduct. Okay, let's talk about Door of Hope's policy. Door of Hope has a strict policy against sexual harassment. It's in Section 3 of the Employee Handbook. And it tracks pretty much what the law is. It talks about, in other terms, quid pro quo harassment and hostile work environment harassment. It prohibits it, as it should, as it's required to. And it prohibits any discrimination on the basis of gender, race, religion, origin, physical or mental disability, genetic information, age, or any other basis protected by federal or state law. It's a good policy. It's what the organization should have. What you should take away from it is that this is all protected to a greater extent than the law protects you. So treat others, love your neighbor like yourself, do unto others as you would have them do unto you. Treat people decently in the workplace, because doing otherwise is prohibited. And consequences can lead up to and including termination. So how do you report sexual harassment? Every organization should have a chain to do that. Door of Hope does. You should report sexual harassment, because if you're a supervisor and you perceive or hear about sexual harassment, you're required to report it to the appropriate people within the organization by the law. It's an obligation. And your employer, if you're the victim, is probably not liable, and nothing's going to happen unless you report it. So unless you report it, not only can you not get relief, but things aren't going to change. And the remedies you can seek if you sue are dramatically limited if you have not reported it. How to report work harassment here? It's in the Employee Handbook, section 4.4. You should report to the COO, Mr. Buck, as the first instance. Alternatively, you can report to the executive director or to the committee members on the board of directors who are responsible for sexual harassment. Let me talk to you a bit about this. It is not unusual for people to feel uncomfortable reporting to a particular person. Sometimes this is because you feel like, oh, I'm reporting this person's close friend for harassment. Or, this person and I had a big dispute this week. Or whatever the reason is, or even this person is part of the problem. Your top priority should be reporting it to a supervisor, to someone higher up in the chain than you. Who you do it to is not of primary importance. It's going to get to these people eventually, and they are going to be decision makers, and they are going to be driving the investigation. But the key message to take away is to report it to a supervisor, and they should then take it up the chain to these people. So if you're a supervisor in any way, if you supervise anyone, you know that if you hear someone comes to you and expresses a concern, you know who to go to.
Clarity question. Let's say a staff person reports to not me or Keith, but a supervisor, even another staff person, I guess.
Right.
Is that staff person, because they now know, required to send it up the chain? Especially, for example, if the person sharing about it or reporting it wants it, for whatever reason, to be confidential.
Important question, and we'll talk about confidentiality. A supervisor is required to take it up the chain, okay? And this can be unpleasant. Someone comes to you, your supervisor, and says, I really don't want to make a big deal of it. I'm sorry, this is one of the tough things you might have to do as a supervisor, and say, I'm sorry, I need to take this further. We'll do everything we can to respect your confidentiality, but we have an obligation to do something about this. If it's not someone you supervise, if you're not a supervisor, then you don't have that obligation. But I think it's almost always the best thing to do. I mean, my first preference would be that you persuade the person to report themselves. You say to them, look, this isn't going to change if you don't report it. I'll go with you. I'll help you. I'll stand by you. But we can't change this. We can't make it better unless you report it. That would be my first preference. Yes?
And another reason to report is because it may not just be that person who's being harassed.
Exactly.
The fact is there may be more than one other, and if one person doesn't step up, this could go on for a long while.
That's exactly right. You say to them, and this is part as a supervisor, as someone running these investigations, what you might be saying is that I understand that this is uncomfortable, you don't want to make a deal out of it, but you have to understand it isn't solely about you, it's about the entire workplace and the other people in the workplace too.
So a supervisor is required to take it up the chain of command if they hear about it. Are they required to disclose the victim's identity or just
Yes.
the offenders? Okay.
If you're a supervisor and if there's doubt as to whether you are, I would like you to assume that you are. You need to go to the people in charge and give them the information. The good thing is if you're not one of those people, once you do that, it's not your problem to decide exactly how to handle it, right? It's those people's problem. Okay. So, bottom line, go to these people if you can, but if it's like the weekend, it's an emergency, they're not available, you're uncomfortable for any reason, it's more important to report it to a supervisor than it is to report it to a particular person. But it's going to go to them one way or the other. So how to respond to a report of harassment if you're not one of those key people doing the investigation. Report it up the chain immediately, first. And by immediately, I don't mean within 15 minutes, but that day. I want you to do it. Okay? Second, document it as instructed by the superiors. So it's likely, a good practice would be, and what I tell people to do, is someone tells you, oh, I had a conversation with this person, here's what they tell me. You say, thank you. Can you send me, and just me, an email with your recollection of exactly what they said? Send it to me. Document it. Memorialize what you're told. And then you follow instructions on what to do next. It's out of your hands, you report it up the chain, it's not your primary responsibility anymore. Freedom from retaliation. This is absolutely key. This is a red line, okay? It's illegal for your employer or any supervisor or coworker to retaliate against you for reporting sexual harassment. And Dorico has a strict policy against retaliation. If you feel someone is treating you differently, retaliating because you reported harassment, you need to tell the supervisor immediately. This is, again, remember how I say, it's the cover-up, not the crime? I would say a third to half of sexual harassment cases are an issue, are bad enough to go to court because not of the conduct, but the reaction to the complaint. Okay? Because someone treated someone differently after the complaint, or there's an allegation that they did. That's how important this is. Okay, let's talk about investigating and responding to sexual harassment complaints. An effective investigation is crucial. And the good news is, you don't have to be Sherlock Holmes, you don't have to be a trained FBI agent. An investigation is just gathering information, making a decision in a responsible, professional way, and exercising something I call communication discipline. An effective investigation insulates Door of Hope. It insulates you individually. It stops both harassment lawsuits and lawsuits by someone you might fire or discipline because of their conduct. And it often satisfies the person making the complaint. This is something people don't appreciate, that one of the key things when people have been harassed and they've made you feel ashamed and different in the workplace, and the nature of the workplace has been changed, is they need someone to understand that and hear it. They want to be treated seriously. They've been hit with this message that you're not worthy to be here. In fact, you're different. And you need to counter that message with a message that you belong here. What happened to you is intolerable, and we're going to deal with it. And if you do an effective investigation and communicate that investigation, that will often satisfy the person making the complaint. So it's the people who are blown off, treated disrespectfully when they make a complaint, who sue for harassment. So what to expect during an investigation? Investigators, and by that I mean the senior people in the organization, will talk to the complaining witness, the accused, their supervisors, their colleagues, any witnesses. They may take steps to separate the complaining witness from the accused temporarily, or to make sure the conduct doesn't continue during the investigation. And if you're part of an investigation. If you've seen something, you've said something, cooperate with the investigators. Make sure if you're a witness that you've told them everything you know, everything you remember. Keep your conversation with the investigators confidential, and don't gossip. This is another red line area where a lot of liability flows not from the original alleged harassment, the wrongdoing, but how people react to it. So a classic scenario is that someone accuses someone else of harassment, people start talking it up and gossiping about it, and before long you've got defamation lawsuits and gossip has become a claim of sexual harassment and so on and so forth. Conducting an investigation here. The key elements are information and communication discipline, discretion, privacy. Okay, treating this as information that only gets exposed to people who have a need to know it. The classic example is my office has 3 conference rooms and they're all glass walled. Okay, so what you would not do in my office if I were investigating someone for sexual harassment is have the receptionist go to their office and tell them to come see me in one of the glass conference rooms and then interrogate them in the glass conference room in front of everybody. You would not report, we don't have a loudspeaker, but you would not say over the loudspeaker, Mr. White, come see the managing partner immediately in conference room A. Something like that. That's not discreet. You would not tell people who don't need to know. Thoroughness. Thoroughness just means that you act as if you care what the truth is. Okay? You do not leave obvious stones unturned. Does not mean you need to send out for DNA tests. This is not CSI. It does mean that if there are obvious questions, you should ask them. If there's a witness who is there, you should talk to them. You should act as if you care to find out what actually happened. Yes?
To balance discretion and then thoroughness, what about interviewing other people that work with this person to see if that behavior is going on elsewhere?
It's a judgment call. So you need to ask first the person complaining, have you seen this person do this to people other than you? Has it happened when other people are there? And then depending on the nature of the conduct, you make a judgment call about whether or not to ask other people. If it's just someone hitting on this one person, you might think, I don't perceive that's likely to be happening to other people in the workplace. If it's, offensive jokes or comments, you might decide to. But you're always going to, and I'll get to this in a second, ask all the witnesses for confidentiality. Reasonable fairness. That again just means that you give the person who's being investigated an opportunity to respond to the allegations. So your key here is you don't want to be sued for wrongful termination or firing someone for sexual harassment, which you can if you do it in a way that seems obviously unfair, that you don't care what really happened. Okay, again, California law at will state you can fire someone for any reason that's not specifically prohibited, but if you do it in a way that everyone says, oh, that's ridiculous, that's completely unfair. If it's gratuitous, like this person complained at something and you don't even ask them whether it's true or not, you fire them, then that's the type of thing where all of a sudden they might start to say, well, they really fired me because I complained about something last week, or they really fired me because I'm this or I'm that. And if you've done it in a haphazard way, that sounds more credible. Here are the pitfalls of investigations. All of these are about communications discipline. Okay? Lack of confidentiality, including people on the email chain who don't need to be in the email chain. Forwarding the email chain outside the email chain. Talking about it in the lunchroom while other people are coming in and out. That sort of thing. Lack of confidentiality, lack of discretion. That's the glass office scenario. Conducting the investigation or announcing it. Gratuitously announcing the results of the investigation. We'll get to that in a second. Lack of documentation. I talked to these people, but I never wrote down what they said, and now it's a year and a half later, and I'm trying to remember. Lack of full opportunity for the accused to respond. I don't mean a jury trial. I mean that you bring a person and you say, this person has said you've done these things, what do you say about that? Failure to inform the complainant of the results. This happens all the time. Companies do the right thing. They conduct an investigation. They discipline the wrongdoer. They counsel them so they won't do it again. They never get around to going back to the complaining witness and say, hey, we took you seriously. We did something about it. and the person is saying, what's going on? These are pitfalls. Timeline of investigation. I'm going to meet the 2 hours that I'm required to give you. I'm going to hit my deadline. Step 1, someone reports harassment. Step 2, the people in charge of the investigation interview that person, the complaining person. Step 3, those people decide if there's any intermediate steps. By that I mean, do you need to do something immediately to protect that person? Okay? So if this is a situation where someone assaulted someone in a workplace, you might immediately put the person accused on leave while you investigate it. If it's like this person occasionally tells jokes that make me uncomfortable, you probably won't put them on leave. Right? It's a rule of reasonableness and good judgment. You make a decision, and probably the way you make the decision is by asking the person, are you okay coming to work tomorrow? Are you really worried right now? Is this something where we need to do something immediately? We're going to be investigating it this week. Step 4, interview the accused. Ask them for their side of it. Step 5, interview other witnesses. Step 6, gather evidence. We'll talk about that in a minute. Step 7, make a decision. And step 8, communicate the decision. Pretty straightforward. Again, you don't have to be a trained law enforcement officer to do this. Interviewing the complainant. You need to explain to the person who's made the complaint that there's going to be limited confidentiality. What that means is you say, look, I have to make things right in the workplace. I have an obligation to you and to other people to make sure this is free of sexual harassment. So I'm going to treat the information you give me confidentially in general. I'm not going to go blabbing it around. On the other hand, I need to investigate this. That means I have to ask people questions. I have to talk to the person you're accusing, and I may eventually have to discipline them. And if that happens, that will involve some loss of confidentiality. So you explain to them, you're not going to gratuitously release the information. You're not going to tell it to people who don't need to know, but you can't promise them you'll never tell anyone. You ask for their information, every event they remember, every witness who was there who might have seen it, any evidence, texts, emails, any documents, anything like that, videotapes. Ask what the complainant wants. This is one a lot of people miss. Okay, what would make you feel like this problem has been solved? What could we do that would make you feel comfortable getting in your workplace? That we've addressed this in a way that makes you feel you're respected and that you're comfortable this won't happen anymore. People worry that complaining witnesses are going to demand that someone be fired, and you've got to decide whether to do that or not. It's usually not the case. Usually someone who's experienced, if it's not severe harassment, just wants it to stop and wants to be treated like a person worthy of respect. And if you can do that, you can solve the problem. Ask the complainant if they're currently afraid. So is this a case where someone grabbed them or physically assaulted them? In that case, you need to take action immediately. If it's not, then you don't. Reassure the complainant that you're investigating, you're taking it seriously, and remind them that retaliation is prohibited and tell you if anyone does anything to them because they complain. And ask them for confidentiality. Thank you for telling us, can you not talk to anyone else about it? So the next is you decide the intermediate steps. Is it really severe harassment? Is something shocking, something physically dangerous? Does the person feel afraid currently? If so, consider putting the accused person on leave, taking them out of the situation. You could consider doing something to protect the complaining person by moving them, but that's risky. You don't ever want to do anything that disadvantages the person complaining, because that looks like retaliation. So you don't want to put them on leave in general. You don't want to move them to a different location because they may find that location less desirable. That looks like retaliation. Interview the accused. Explain what they're accused of. And yes, that involves telling who accuses them, telling them who accused them most of the time. It's important to give them a reasonable opportunity to respond. That's what guides how much information you give them. They have to have an opportunity to say, yes, I did that, no, I didn't do that, and to give specifics. Ask them for their side of events. Ask them for if they know anyone who saw this, if there's any evidence, emails, texts, all the other stuff that modern life produces in our communications with each other. Explain what's going to happen in the investigation. I'm talking to you, I'm going to talk to witnesses, and I'll make a decision. Remind them of the policy against retaliation, and request confidentiality. Similar to what you did with the complaining witness. Interviewing witnesses. Ask them for confidentiality. Let me put it more strongly. Tell them to keep it confidential. Say, you will not discuss this with anyone else but me. Ask direct questions about what they saw, if they can confirm anything, if they've seen similar behavior. Ask if they have their own concerns about the person who's accused or about conduct in the workplace. Explain again the importance of confidentiality, and remind them of the policy against sexual harassment. How do you conduct interviews right? Well, again, it's all about communications discipline. You do it in private, you do it discreetly, you only include people who need to know in communications about the interview, and you use secure and responsible transmission and storage of investigation materials. That sounds like something a consultant gets paid $600 an hour to say, but all I mean is that you don't leave your notes from the interview on the printer, and you don't, store your memos about the interview on a server that everyone has access to, right? You document promptly. That's part of communications discipline. If you do an interview, I want you to write it up that day. Making a decision. Okay, supervisors, and this is tough for a lot of people. There's no jury trial here, right? There's no judge. There's no one else making a decision. It's on you. And so make a decision. Make it based on your understanding of the people, based on your judgment, based on your assessment of who's telling the truth. The key is not whether you get it right. You're human, you're fallible, you may not get it right all the time. The key legally is whether you made a good faith effort, bless you, to investigate. Whether you treated it as if you care what really happened. Okay? So if you did it basically the way you would want it done if you were accused in the workplace, that's not a bad guideline. So don't fail to interview someone who is obviously a witness to it. Don't fail to look at a videotape that the accused person says will show what happened. Do the steps that show you care what the truth is, and then make a decision about what happened. Make a decision about discipline and what type of discipline. Anyone from a reprimand to termination. Okay? And that too is up to you. It depends on the severity of the conduct, how it's affected the workplace, what the complaining person wants, and your own discretion as a leader. Communicating your decision. Obviously, always tell the complaining person. They need to know what the result of their complaint is. And that means you reveal a certain amount of otherwise confidential information to them. You might say the person's been terminated. You might say they've been disciplined. You wouldn't necessarily tell them exactly what the discipline is. You wouldn't say this person has been suspended without pay for 2 weeks, but you might say this person has been disciplined. Yes?
If the investigation takes a fairly significant length of time, do you keep the complainant notified along the way, or just say, I'll come to you when I finish this, just be patient?
Reasonably so. I would say that in an organization this size, unless there are circumstances I can't immediately foresee, then it should not take a long time. I would tell an organization this size, I would like any investigation to be done in not more than 2 weeks. I would prefer that it be done in a week. Okay? Because one of the danger zones, red line areas, are investigations that drag on so that the conduct continues or it appears that you don't care. Would it be catastrophic if it were 3 weeks or even 4 weeks? No. But if you get it done in 2 weeks, I am highly confident in my ability to portray it as extremely responsible and hardly anyone could complain about it. So that's the rule of thumb I use for smaller organizations. Mega organization where you have to go to the office in New York, that's a different, And if you ever had something where the complaining witness is on vacation for 2 weeks, then that would be different. But you want to do it promptly, and promptly means weeks, not months. Communicate to the accused, make a written record. This depends on the degree of severity of the discipline, but tell them this is the discipline we're doing, and the same practices you probably use for other forms of discipline, for other violations, probably what you should use here. Written record, this is what we're doing, we're asking you to sign it, not to agree with it, but to acknowledge we told you this, making a record of what you told them and they told you. Communications discipline. It's all about communications discipline. No public announcements. So-and-so has been deemed guilty of sexual harassment and is hereby disciplined in the following way. It might wind up saying so-and-so is no longer with the organization. It might wind up saying we're going to have a refresher course on sexual harassment prevention, from which people may draw conclusions, but generally do not gratuitously talk about what a person was disciplined for or how they were disciplined. It might be appropriate to remind everybody of sexual harassment rules, particularly if it appears to you, based on the investigation, that there's an ongoing problem. Finally, where can you get more information? Perfect. You can get more information about sexual harassment, the prevention of sexual harassment, and your rights and the remedies if you feel you've been harassed from your supervisor, from me, should we need you, from the United States Equal Opportunity Commission, EEOC.gov, or from the California Department of Fair Employment and Housing. All of them have tons of information about what your rights are, what your remedies are, materials to use in the workplace, posters to put up in the break room, anything you want, they have. Okay? Thank you. I know it's not a subject that you necessarily want to spend 2 hours of your day. It is required by law, that's my excuse. It's not purely gratuitously cruel on my part. Any questions, eventually?
Any questions, not just for Ken, but about our policy specifically in reporting structure?
And you all should know that Ken is doing this on his own. He's not being paid. This is his commitment to Door Vote.
My pleasure.
Thank you.
Thank you for your time.
All right, so, we are gonna do lunch, so Melissa, do you have anything to tell us about the lunch? No? Okay. Keith, would you like to pick us?
Sure. Lord God, thank you for taking us through a difficult kind of topic. Thank you, first
Yeah.